Good afternoon, everybody, and welcome to this week's Bonavero discussion group. I'm Kate O'Regan, the director of the Bonavero Institute of Human Rights at Oxford, and we are absolutely delighted this week to welcome one of our advisory council members and a very distinguished British judge, Lord Dyson. Lord Dyson has recently written a book which will be the basis of the conversation between him and me this afternoon, called A Judge's Journey. And it talks about it's autobiographical. It tells the story of his life from his early childhood in Leeds all the way up to the present, and gives extraordinary insights, I think, into his career and his life. I was telling him before we started our conversation this afternoon that one of the things I most enjoyed about the book was the way it mixed the personal and the professional. An awful lot of professional autobiographies sort of render the personal invisible under the pages. And for those of us who are grappling to live a life that is both personal and professional, it makes it seem completely easy and without any difficulty. And I think, Lord Dyson, your book is really unusual in this regard. And I wonder if you might tell us a little bit about why you thought you should write it.
Yes, I sometimes wonder that myself. I think there are a number of reasons. First, I had for a long time thought it would be nice to write something about my life for my family. I think that's understandable. I never, for a long time, never crossed my mind that I might write something for a wider readership. But the seed was planted in my mind really after I gave my valedictory address in the summer of 2016, just after I'd retired as Master of the Rolls. Unlike most valedictory addresses, which tend to be fairly light affairs, self-deprecatory and all that kind of thing, that wasn't what I did. I wanted to say some fairly serious things. I wanted to say something, and it was fairly brief, something about my family background. I am Jewish. Both sides of my parents' families came from Europe, and to express my enormous gratitude to this country for allowing my family to settle here and to allow me in particular to flourish here. And you see, and I talked a little bit about my grandmother, who spent several months in Belsen during the latter stages of the Second World War. And there was a packed court, and there was a sort of, I felt there was sort of tension in the air, and people were really moved. And after it, a lot of people said to me that they'd never heard an address like that before. They were very moved by it, and they'd like to know a lot more about me and my background. So there was that, and that really set me thinking about perhaps I should write something for a wider readership. And then I think I would couple that with the fact that the more I thought about it, the more I thought it would be a good thing for me to write something about what it's like to be a judge. That's obviously only part of my life, but I felt that judges on the whole are wrapped in mystery so far as the general public is concerned. I don't see why they should be. Judges perform a very important role in our national life. And so I wanted to say something about that as well. So these various factors which all came together, which led me to decide to write the book.
So, I mean, one of the things you do, you tell the book in a kind of chronological order, and you start with your early life in Leeds, and you start, in fact, even before that with your parents and grandparents, and then into your early life in Leeds. I mean, can you tell us a little bit about that? Tell us a little bit about what it was like growing up in the sort of aftermath of the Second World War and in Leeds, and how it compares to your kind of the current day?
Well, I could spend the next hour talking about that. I was born in 1943, so I did, my very, very early years were immediate post-war period. People didn't talk very much about the Holocaust. In fact, I don't think the word Holocaust even had surfaced at that time. I don't know when it first became sort of common currency. But it was only gradually that one learnt about it. I had a comfortable upbringing. My parents ran a dress shop, and I was sent to a direct grammar school, and I had a pretty privileged life. I mean, I certainly didn't come from a difficult or disadvantaged background. Far from it. I had a loving family for whom education was hugely important. My parents did not want myself or my brother to follow them into running their upmarket dress shop. I think they would have regarded that as a failure. And they wanted both of us, my brother and myself, to have a very good education. And I had a good education. It was a fairly traditional school. The way in which the school was run was very much, I think, still the way in which a Victorian school would have been run. Quite traditional, pretty unimaginative. The teaching was not very imaginative. I wasn't really inspired by teachers at school. When I've said that, when I've been back to my old school much more recently, I'm not sure that that's gone down very well, but it was pretty old-fashioned and unimaginative, uninspiring. But I was a diligent student. I worked hard. The work ethic was instilled into me from a very early age, and I suppose I could have gone one of two ways. I could have reacted against it and decided that that was not for me, or I could have done as I did, go with it and enjoy learning, enjoy studying. And the idea of going to Oxford would have been totally unthinkable until really quite late in my school career. But then it was suggested, because I was good at classics, Latin and Greek and so on. And in those days, clever boys, and it was a boys' school, who didn't go on, who were not on the science side, were encouraged to do classics, which is what I did.
And you came up to Oxford and was a member of Wadham College, and by all accounts, you thoroughly enjoyed your time in Oxford. Although, as I recall, you were quite ill as you were coming up towards your finals, and that affected your final result, which was a big disappointment to you.
Well, it was a big disappointment, and it really was a very not only that, because one gets over things like that, obviously, but I was all set to go and spend a year after Oxford teaching at Cornell University, teaching classics, and who knows what would have happened. I think I might well have had an academic career in classics, because I was very keen on that. So but I had to come back to Oxford the summer after the summer when I should have taken my finals, and so I'd lost a year, and I don't know. I decided during that year that perhaps classics was not for me. I was given some very good advice actually by my classics, one of my classics tutors at Wadham, who said, if you really want to do classics, I would certainly strongly support you. But my advice to you is don't do it unless you have an absolutely burning passion to do it, because the opportunities in academia in classics, there are not that many of them. And so my advice to you is don't do it unless you really, really think that's the only thing you want to do with your life. And that was a very high test. And I put the mirror in front of me and I didn't meet that test. And looking back on it, I'm so grateful for that advice, because I did enjoy the classics. But I did then move into the law, which is the reason why I went to Wadham in the first place, because Wadham, I was told, was a very good law college. And I got a scholarship to read classics, I was going to read law at Wadham, but the warden, the great Sir Maurice Bowrer, talked me out of it and said, if you're going to be a lawyer for the rest of your working life, well, then you shouldn't read law. I mean, it's a very kind of strange and maybe a rather old-fashioned view, but and he was a very powerful person, and I was a fairly shy, diffident sort of person, and so if confronted with that very, very strong steer, I decided not to read law. And my wife, who did read law and was a very good lawyer, said that for many years I suffered from not having a proper grounding in law. And I think she may have been right, but I learned on the job. So that year, which was forced on me by that very nasty operation I had to have, was a big turning point in my life. And because if I'd gone to New York, to Cornell, who knows, I might well have stayed there, and my life might well have been very, very different.
Yeah, I suppose it's one of those life lessons that sometimes, adversity redirects us, and sometimes in ways that turn out to be excellent in the end, or very good in the end. And then you talk about your sort of early days at the bar, and going to the bar and joining a set that was very much a kind of construction law set, a building practice, and all the uncertainties of those early years, and thinking about how your practice is going to go. I mean, do you want to talk a little bit about those early years and those uncertainties and the difficulties of kind of finding your way in the profession?
Well, when I joined the chambers, they were not actually construction chambers. They were general knockabout chambers. And I didn't have any contact at the bar. I was introduced to the chambers by my sponsor at Middle Temple. All students were given a sponsor. And he introduced me to somebody in the chambers. And in those days, looking back on it, I mean, it was a charmed life in many ways. You didn't have to go through this dreadfully stressful business of applying for pupillage, and which I know is so difficult now. I was just introduced to a man called Patrick Garland, who later became a High Court judge. And we spoke for about 10 minutes, and he offered me a pupillage. And it was as simple as that. Now, I knew nothing. I was really, looking back on it, I was so kind of unprepared and had done so little research into different kind of chambers, and I'd given no real thought to what kind of practice I wanted to do. I'm appalled when I look back on it, actually, how disorganized I was. But anyway, the chambers, as I say, at that time were general knockabout chambers. And I spent the first couple of years of my professional life doing quite a lot of matrimonial, as it was then called, matrimonial work. I think we now call it family work. Quite a lot of possession actions and small landlord and tenant cases, a couple of jury trials, criminal jury trials. And that was enough for me to make me realize that the criminal bar was really not for me, and the criminal practice was not for me. I also realized after a year or two that family work wasn't for me, because I really hated these cases where men and women were at each other's throats and they were fighting over the children, and it was all really horrible, and I didn't find it interesting. But the chambers, the shape and the nature of the work in chambers changed very, very quickly, really under the influence of a man called Donald Keating, who was a senior member of the chambers, who had written a book on construction law. And it was at a time where I'm now talking about the very early 70s, when there was a sudden upsurge in the amount of construction work, law work. And before I knew what was happening, I was doing a lot of construction work. I would never have expected that my practice would have gone in that direction. And I mean, looking back on it again, I quite enjoyed the work, because it was work, and it was well-paid work, and some of it was very interesting, but frankly, some of it was very dull. But I was good at it, and I managed to gradually attract good solicitors. And before I knew where I was, I had really quite a large successful practice. But it was like so many things in my life. It wasn't planned. It's just that opportunities presented themselves, and I took them.
I mean, again, it seems, building a career is a bit of a mix of hard work, good luck, and serendipity in a kind of a way. Things happen to you, and sometimes it's difficult to predict how it's going to go. Now, that certainly comes through very strongly in your book. You mentioned a moment ago your wife Jacqueline, and about the extraordinary support she's been to you, and also your reflections in the book in some ways on the differences between her experience in her career and yours. Do you want to talk a little bit about that? Of course, at that time, I can't imagine how many women would have been in Jacqueline's law class, but it would probably be a very small proportion. And so the number of women in the profession was very little, and that is something we've seen a tremendous change about. But I'm sure people who are here would like to hear you talk a little bit about that contrast and your reflections on it.
Well, you're right. I mean, she went to Birmingham, read law. She did extremely well. She got a first, and there were pretty few and far between in those days. I think there was a degree of generosity around now, so far as the giving of first is concerned, which there wasn't in those days. And she was very good at law, and she was fortunate in that she had parents who were very encouraging of her in a way in which I think a lot of young women at that time didn't have. She was going to do a BCL at Oxford, actually. She was offered a place at St. Anne's to do a BCL. And this would probably shock a lot of young women today, but it's a fact and I must tell it. She met me, and we fell in love very quickly, with alarming speed, really, looking back on it. Anyway, she decided that she wanted to stay in London because she had met me, so she gave up the offer of BCL in Oxford. As I say, I imagine most of the young women who are listening in today, watching in today, would be shocked by this. And looking back on it, I think it was touching and lovely, and it all worked out well. But I'm sure we would have still stayed with each other even if she'd gone to St. Anne's. So what she did was to do an LLM at UCL in tax and company law, and then she did a bit of work at the in solicitors, I think that's what they were called, the solicitors department of the Inland Revenue, at a time when I was just starting practice at the bar. And then we had children again with speed, with which I think modern women, young women, would find rather shocking or at least a bit surprising. And so I mean, she could have said, I want a career and we'll have nannies, and she would have been a terrific lawyer, terrific solicitor, actually, in my view. But she didn't want to do that. So she gave up work, and certainly when Stephen, our second, came along, she did a bit of work at the CAB. And then when Stephen was 4 or 5 and was about to go to school, she saw this advert, UCL advert, for a lecturer in tax law. And so she took that, and she spent 37 years at UCL as a lecturer, and then Dean of Students for the whole university for, I think, 6 years. And that is not a career course that she would have taken, I think, had she not put her family first. And she was remarkable the way she managed to combine being a full-time lecturer and then Dean of Students at UCL with being a brilliant mother and a terrific support for me. So you could say that she made a sacrifice. She would never put it that way, but you could say that she made a sacrifice of her career, because this is not the career she would have chosen. She's not an academic. She's a very practical person, and she would have liked to have been a practical practicing lawyer, I think, ideally. But she has been a fantastic support to me, and this year we celebrated our 50th wedding anniversary, I have been incredibly fortunate.
Well, I mean, it is a wonderful story, and at the end of the day, you know, life, as I say, it's this mixture of the personal and the professional, and kind of worthwhile, rounded life requires one to try and manage both those things, and it does come through very well in the book how both of you have kind of grappled with that over the many years. Turning then to your appointment to the bench, you tell the story in the book and kind of your early years on the bench. Do you want to talk a little bit about how you found the move from being a practitioner and a barrister to being on the bench, and what you enjoyed and what you found difficult?
Certainly. I'll just say briefly a word about the appointment process, because again, it's changed so much.
Yes.
I was appointed under the old, now wholly discredited tap on the shoulder system, and it was an appalling system. The tap on the shoulder was a tap on the shoulder from the Lord Chancellor. The system worked quite well in the sense that the people who did the research to try and find what they regarded as suitable people to appoint were pretty savvy, and I don't know how they did it, because I didn't have a very high profile practice at the bar, and they somehow found me. David Newberger, who did mainly landlord and tenant work, he didn't have a high profile practice at the bar. They found him, so they had a good system for finding people, but it was not an acceptable system. It inevitably meant that although they appointed some, I suppose I would say this, but they appointed some good people, there were lots of other good people who they missed as a result of this process. It was a very narrow system, and it, in a way, even worse, I think, is that the way it was done, which was sounding out senior judges' views about X or Y, meant that a senior judge who, however possibly unjustifiably, was opposed to a candidate, could completely destroy that candidate's chances. And I know from what I've heard that Lord Denning, for example, blocked a QC from getting onto the High Court bench, and he just had it in for him for whatever reason. And the idea that one person, however eminent, can do that, I think is just terrible. But anyway, that's how it was. I was tapped on the shoulder, and I was appointed to the High Court as a Queen's Bench judge. And I had some judicial experience before that, because I'd sat as a recorder doing smallish criminal cases with juries, and I had also latterly sat as a deputy High Court judge. So I'd had some experience of.
Oops. Could you hear me then? I don't know. We lost you for a moment, so perhaps you were just saying that you'd had some experience, and that's when I lost you. So maybe just recap a sentence or two.
Well, I'd had some experience, and I really enjoyed it. I just enjoyed the process of deciding cases, deciding disputes, and trying to get the right answer fairly and efficiently, and that sort of thing. I had enjoyed my 24 years as a barrister, because I had enjoyed the cut and thrust. I had enjoyed the excitement of trying to persuade judges to accept your submissions. I had enjoyed cross-examining witnesses and so on. This was completely different. And I think probably I enjoyed it more, to be honest, than being a barrister, however much I enjoyed being at the bar. I just found it so satisfying to be presented with a problem which parties were at loggerheads about, and trying to get the right answer as best I could, to express myself clearly and reasonably succinctly and to do it in a way which was fair to the parties. I just found that very satisfying. And as a High Court judge, one had very little opportunity to contribute to the development of the law. But I mean, I did have one or two cases where I did do that. And I found that extremely exciting and interesting. And I realized the more I went on, the more interesting I found the law to be, because my practice at the bar, certainly doing construction cases, I hadn't had much exposure to fundamental questions of law. It was mainly a fact or construction of contracts. When I moved chambers, as I did, and I explain in the book, I moved chambers not because I wanted to become head of those chambers, but because I wanted to diversify my practice into wider fields. I suddenly realized that there's this great world outside of fascinating law. And so to have the opportunity of being part of that and contributing to it, I just found so incredibly interesting.
I mean, that definitely comes across in the book, and I mean, it's a wonderful mix of a kind of your reflections on some of the cases you sat in, and one of the things that struck me was how, you know, relatively quickly you came across the field of public law, which hadn't been an area in which you'd practiced at all, and that you actually took to this area and found it a very interesting area to adjudicate in. I mean, do you want to talk a little bit about your first encounters with public law? You've become such a distinguished public law judge that it's, I think, probably hard for people to realize that hasn't always been, your kind of expertise as a lawyer, and that it really is something that you encountered on the bench. Do you tell us a little bit about that?
Well, yes. I mean, it all arose because when Lord Taylor was Lord Chief Justice, and I was sitting, it was fairly early in my career as a High Court judge, and he was looking for another judge to do public law cases. In those days, there was a thing called, they called it rather quaintly, the Crown Office List, which is the predecessor of the Administrative Court. And it was quite small. There were only a small number of judges who sat on the Crown Office List because there wasn't an enormous amount of work. Today, that must seem strange. Anyway, he was looking for somebody, and I was sitting with him, I think in Cardiff, probably, I remember. And he said, well, you know about judicial review, don't you, John? He said. Well, I didn't say, well, no, I don't know anything about judicial review, because it just sounded fun and exciting and interesting. And he said, well, would you like to go on the Crown Office List? And I said, yes, that would be great. So that's how it started. And so I was thrown in at the deep end. This may seem odd, but that's what happened. And I found that I did take to it. I just loved it. I found that the factual subject matter interesting, very varied. I found that the law interesting. There was a lot of statutory interpretation involved, which I enjoyed. I think my classical training, Greek and Latin texts, and poring over those texts, I think that may well have helped me to be quite careful and precise in the way I looked at language. So there was a lot of statutory interpretation. And then ultimately, it was all about what seemed to me, at any rate, what was fair and sensible. I'm putting it very crudely. And so I loved that. And it did thrust me into the public eye in a way which I hadn't been at all. And that was a bit of a shock, really. Again, you may say that's a bit naive of me, but I hadn't really cottoned on to this idea that if you become a judge, and certainly if you start doing that sort of work, you are in the public eye. And that was a new experience for me. And one of the earliest encounters I had with that problem, if you like, was in the case which I think I describe in the book, the case of Norney.
Yes, I was going to ask you about that. Yes.
Well, people are very excited now, and I'm one of them, about the sort of things that Priti Patel is saying, and indeed outraged by some of the things that she is saying. But I had to remind myself that she's not the first Home Secretary who has said things which judges find outrageous, or at any rate unjustified. There's quite a trail back in time, and Michael Howard was Home Secretary in the 90s. So, I found myself on several occasions quashing decisions that he had made. And one of his decisions involved it involved the question of when somebody who was imprisoned, when that person's case should first be considered by the parole board for early release. And he applied a policy which said that you don't ask the parole board to consider this until the end of the tariff period, the fixed term period after which questions of release start being considered. And because of the backlog, this inevitably meant that every prisoner, however deserving of early release, couldn't be released early for at least 6 months after the end of the tariff period. So there was a challenge to this policy. It came in front of me, and I thought this was irrational. There was no rational basis for delaying until the end of the tariff period before you consider early release for parole. So I said this policy was unlawful, and we were in bed on the Thursday morning when I handed down the judgment. The Home Secretary's QC said he was not asking for permission to appeal. So I thought that was the end of that. But on the Friday morning, we were listening to the Today program, and it was John Humphreys in those days, and he had Michael Howard. And Michael Howard said, and he said to Michael Howard, well, another reverse at the hands of the Judiciary Home Secretary, what do you say about this? And Michael Howard said, well, the last time this judge, meaning me, the last time this judge found against me, he was unanimously overturned by the Court of Appeal. We will see what happens if I appeal this time, he said, knowing perfectly well that he had no intention of appealing, and he never did appeal. But I was really shocked about this, because I knew he had no intention of appealing, and he was just trying to rubbish me as being an incompetent judge. And I really was shocked. I shouldn't have been shocked, because politicians are politicians. And Michael Howard is a clever man, and he was in a bit of a hole. And years later, Joshua Rosenberg wrote a book called, I've forgotten what it was called now, but it was about the struggle between the judiciary and government.
Trial of Strength, I think it was called.
Thank you. Trial of Strength, thank you. And Joshua interviewed Howard about this story. And Howard said, well, the point I was really trying to make was, it's sometimes very difficult for ministers to get it right, just as it is sometimes difficult for judges to get it right. That was the point he said he was trying to make. I mean, it was utterly disingenuous point, but you have to admire the cleverness of it. So that was a bit of a wake-up call for me, to realize that as a judge in the High Court, you are in the public eye, and I don't think that should, for 1 minute, influence your decisions. But I think it's important to have that in mind when you are doing what you're doing and the way you express your decisions.
Yes, and I mean, it does require certain kind of both robustness and calmness of temperament in order not to let yourself be deflected by those kind of debates, because at the end of the day, that's, I suppose, what being an independent judge requires. But inevitably, it can feel hurtful, especially when one can't respond. So one of the issues that I just wanted to explore before we finish and open up to some questions is this complicated question that arose in the decision of Al Rawi you and I have discussed before about the extent to which one can use the common law to develop principles and the extent to which one needs Parliament to intervene. And I mean, I wonder if you just want to reflect on that a little bit about this is where, in a sense, judges have to bring a feel for what is appropriate in the common law up against the sense of when it is appropriate for an issue to be regulated directly by legislation, by Parliament.
Yes, well, you'll know the nature of the problem from your own experience. It is a very difficult problem, I think. The Al Rawi case is an interesting case because in one sense, it was a case about procedure. And procedure is classically an area which is really not a matter for Parliament, it is a matter for the judges. The judges really decide how cases should be heard and the process by which they should be heard. That on the other hand, and the reason why I was persuaded in Al Rawi that we should not develop the common law so as to introduce a closed materials procedure as a matter of common law, but to leave it to Parliament, was because it seemed to me that what was fundamental about this was that a closed materials procedure does involve an inroad into some fundamental principles. It's not just a straightforward matter of procedure. Fundamental principles of open justice, fundamental principles of people who are facing litigation against them, the right to know everything about the case that is being relied upon against them. And a closed materials procedure, on the face of it, is a breach of both of those fundamental common law principles. And I thought those principles were so important that it wasn't really for the courts to decide to introduce them. It was a matter for Parliament. I think there was one dissentient in the Supreme Court on that point. But these are issues which is quite difficult to pin down. I mean, people have, obviously, you have to form a view and you have to defend the view you form and explain it. I mean, I do think explanation is so important in everything that one does as a judge. Explain, explain, explain. But on the other hand, if you think about it, the judges have developed the common law in some fairly remarkable ways. And nobody's complained about it. I mean, take Donahue and Stevenson, for example. Yeah. Take the cases on immunity from suit. The immunities enjoyed by lawyers and enjoyed by expert witnesses. These things are these developments in the common law have been massive. They have actually affected far more people in society than any of the things that people get so worked up about, like prorogation and that sort of thing. And yet nobody seems to bat an eyelid about that. So I find that quite a mystery. Nobody, as far as I'm aware, has ever suggested that the House of Lords had no business deciding Donahue and Stevenson, and that really that should have been a matter of Parliament. And I've been involved more recently in cases about, we had a case when I was in the Supreme Court called Jones and Caney, which was about whether expert witnesses should enjoy immunity from suit for claims for negligence by their clients if they had. And everybody, I think, accepts that it would be quite wrong that expert witnesses could be sued by the the other side. But the question of whether your own expert, who makes a complete mess of the case for you, should enjoy immunity for that. Now, and in Jones and Caney, we said, but only by a majority, that expert witnesses should not be immune from suit in such a case. But Brenda Hale actually was one of the minority who went the other way, and she said she thought that was a difficult question which should be looked at by the Law Commission, and then should be the result of parliamentary change if it was to be changed at all. So people have different views about these things, and I find it quite difficult to lay down any kind of principle. I think I gave a lecture, the Bentham lecture at UCL some years ago, called "Are Judges Too Powerful?" And I think I tried to discuss this a little bit. Well, I did discuss it a little bit, but it is a big, important subject. And we can't, I mean, we haven't got time to go into it in more detail.
An interesting one, and one that sort of lies at the heart as well of questions around separation of powers, what's the nature of a democracy, and as you say, beyond a full elaboration today. But there are a couple more things that I wanted to explore. So one is that in some ways you played a leadership position in the judiciary at a time when the character of the judiciary within the British Constitution was going under a fundamental change, or some of it was just before you played a leadership role and some of it during your time. Both the establishment of the Supreme Court, the change in the role of the Lord Chancellor, the, in some ways, shift to the senior judges themselves for managing the process of the administration of justice and the civil administration of justice in particular. And I mean, looking back at that now, a lot of that was done, I think, at least one of the reasons was to try to establish the judiciary, as it were, as a separate branch of government responsible for its own affairs and managing its own affairs. And of course, appointments, you mentioned appointments would be another part of this picture. Looking back at that in the light of your experience before those changes, by and large, do you support them? Do you see room for kind of further development, or do you think that the way in which the institutional changes have developed has been a salutary and sustainable development?
Yes, I do support them. I think it has been a very good development. I think that it is hard for judges, some judges, to take on these roles, particularly because all judges who take on these roles, myself included, don't want to give up their roles as judges. They don't want to stop deciding cases because that's why they became judges. And that's what they love doing. At least most of them love doing. I can think of one or two senior judges who perhaps, who are very good at this administrative side of things, who perhaps would have been quite happy to give up being judges altogether. So it's quite hard to combine being a senior judge, because on the whole, the judges who take on these leadership roles, so far at any rate, have been senior judges. And I think that's probably right, because you want to make sure that the rest of the judiciary, who are being told what to do by the judges in leadership roles, respect those judges. And one of the ways in which they will respect them is if they've seen the work that they do and they find that impressive, they're impressed by it. So I remember going actually to the Judge Institute in Cambridge, I think, some years ago, when we had one of these all-day seminars discussing leadership roles and that kind of thing. And the person who was running the seminar said, well, you're crazy trying to be writing these, hearing these very important, difficult cases, as well as doing all these other things. It's just not possible. and when I look back on particularly my 4 years as Master of the Rolls, when I was determined to keep up the momentum so far as deciding the difficult, big, important cases was concerned, when I look back on it, I can't really believe that I did all of that, but I did. And there was a price to pay for that. In my family life did suffer as a result, which I regret. You can't do absolutely everything, and you have to make choices. But to come back to your principal question, I do support the general principle that the judges should be in charge of the judiciary and the way in which the system is run, clearly in conjunction with the government. I mean, we can't ignore the government. The government has a part to play in all of this, but it's a collaborative role. And my sense is that on the whole, certainly so far, the government well understands that and respects the senior judiciary. So I don't think there's any question of us going back to the pre-2005 Act days when everything was run by the government and the judges just basically did as they were told. I mean, I think things like listing, the judges had a role to play in that, but I don't see us going back to those days. And on the whole, I think it works well, but there is a price to pay, and judges are expected to, the leadership judges are expected to do a massive amount. And if they want to keep on deciding the cases, hearing the cases, then it's hard.
Yeah, and that becomes very clear from the book when you basically have 2 chapters on your life as Master of the Rolls, and the first is really the administrative burdens that you bore in that leadership capacity, and the second is on the cases that you heard. I'd like now to turn to, I think, something that is concerning many of us, which is the sense that the role that law and judges are playing in the British Constitution is now a matter of debate and to some extent under attack. You spoke already a little while back about the letter of which you were one of the co-signatories, responding to statements by both the Home Secretary and the Prime Minister about the role of lawyers in providing defence to people who are at risk of deportation, and and criticising the role that lawyers play there, and the fact that you and 2 other of the former members of the Supreme Court and a very distinguished array of senior lawyers and others felt that you had to call upon the Prime Minister and the Home Secretary to apologise for their critical comments. At the Bonavero, one of the things we do is we are partner in a law clinic, legal aid clinic, which provides advice to prisoners at HMP Huntercombe, which is a prison for foreign nationals, where by definition almost every prisoner is under threat of deportation, and that clinic has now been running for more than 2 years, actually, and so in some ways we felt we were sort of at we were part of the targets of that criticism, and I just wondered if you might just reflect for a moment on the circumstances in which it's appropriate for judges to speak out when political statements or statements of this sort are made, and secondly, whether you have any thoughts about how we can kind of reignite a sense of the importance of access to justice, in the broader society, that people realise that actually it is very important for people to be defended and to have access to lawyers to defend them in circumstances where they're coming, where they're in kind of circumstances of vulnerability.
Well, these are grave and difficult questions. That letter that was sent to The Guardian, which was signed by, I think, 1,100 people in the end, it was the first time I had ever written a letter to any organ of the media at all. So I don't think that judges should be popping up left, right, and centre, speaking out. And I do think it's quite important that judges should, on the whole, and even former judges on the whole, should be quite careful about what topics they choose to, controversial topics they choose to raise their voices about. I mean, this is not an easy area, because the days when judges, and even former judges, were expected to keep their lips firmly sealed, those days have long gone. And indeed, it's quite interesting that one of the things that judges of the Supreme Court are expected to do, and it's part of the job description, is to give lectures as serving judges. And I gave lots of lectures, and in fact, quite a number of them are collected in a collection of my lectures and speeches, which was published 2 years ago. And so there is this question about, you know, how far do you go? I draw the line. I think judges have got to be prepared to be criticized for their decisions. I mean, it would be ridiculous if people should be inhibited from criticizing judges for their decisions. And judges have got to have shoulders broad enough to be able to take that, and to expect that the criticism may not always be fair. Politicians are politicians, and that the judges can't answer back. And that goes with the job. I think one has to accept that. But the reason why I signed up to that letter was because I thought this was something different. This was not criticizing a judge for a particular decision. This was criticizing a whole category of judges who do a category of work, and saying that all of them were really to be condemned effectively for doing no more than their job. I mean, I think I made this point when I was interviewed by The Guardian. You will always find a few rogue lawyers, of course. And indeed, this is a point I think that was made by Lord Burnett, the Chief Justice, in a recent decision where the government lost, and he made the point that there will be a minority of lawyers who will abuse the system, and of course there will be, and they should be criticised for that. But the vast majority of lawyers, I am absolutely sure, are people of integrity who are doing a difficult job to the best of their ability, and they are acting for people who sadly, in the eyes of a lot of people in this country, are not really popular. And so with one stroke, to condemn the whole lot of them as being activist lefties who should effectively stop acting, doing their job, I thought was absolutely unacceptable. And the language used was inflammatory, and I felt so strongly about it that I thought that I was willing to put my name to it. And I have actually, I was on the Today program, I think last week, talking about this, and I think I'm being interviewed by the FT. So there's a lot of interest in this now. And it's quite a fine line, isn't it, between saying we have freedom of expression, which of course is fundamental, and people should be free to criticize everybody and judges. And most of the time, the government, in my experience, have been very restrained in the way they've been critical of judges. And when I decided a case against government, which I did quite a bit, the response was usually fairly restrained and measured, saying that the government was, quotes, disappointed, unquotes, which was coded language for saying they were furious, but that's how they responded.
Yeah.
That's fine.
Yeah. No, well, thank you. And, you know, many other things I would like to put to you, but we've got some questions from our audience. And please, just to remind people in the audience, please put in your questions if you have them. And also to remind people in the audience that there is a code number in the chat for you to be able to buy Lord Dyson's book with a discount code. But turning to the first one, and it's from a colleague who wanted to ask you to talk a little bit about your role in the response by the organisation Justice to the current independent review of administrative law that has been established by the government, and which had a series of issues to be investigated, largely, however, addressing the question of whether there were areas of executive conduct that ought to be, to some extent, outside of the scrutiny of courts, and to consider questions of codification and also procedural questions like standing and costs. Could you tell us a little bit about what Justice has done there and your thoughts on that? And I know that could take a long time too, so just give us a playback.
The shortened version. I must say I was delighted to be asked by Justice to chair this terrific working group of about 7 or 8 people, drawn from people who represent claimants and people who have acted for the government. It was very important to have a broad spread of experience. And we put together a paper which runs to about 50 pages, quite long, but there was a lot of ground to cover, including dealing with some of these procedural points. Very briefly, the view, and there were no dissentients, we were all of the same mind. We were very opposed to codification of the grounds of judicial review. Some people have had more constitutional grounds for being against that. Being a fairly practical sort of person, I just couldn't see the point of it. The fact is that however you choose to draft this thing, it would be so difficult to draft it other than in a fairly broad way. And this would require interpretation, and you just have lots and lots of cases, and you'd be no further forward. I don't honestly think, I mean, it's very difficult. The whole of this process I found very troublesome, because it wasn't the traditional consultation process where the government has thought about it and then has made a provisional decision to do A, B, and C, and wants to see what people think about A, B, and C. So we didn't have any draft codification or even a suggestion as to what it might look like. So we were really fighting against something that we didn't know really what it was. But anyway, it seemed to us, it was clear that however it was formulated, a codified set of criteria for judicial review could only be at a fairly high level of abstraction. And so the devil would be in the detail, and all the interstices would have to be filled out by the judges, and you just have a whole mass of new case law to look at in addition to previous case law, because you couldn't just expunge previous case law and say that was of no consequence. Of course it would be of consequence. So it seems a complete, I think it's a completely crazy idea, but anyway, there it is. On the question of actually defining justiciability in some sort of statute, again, we were very opposed to that. Our view was that it's far better to leave it to the judges, as has always been done. The judges have, over the years, produced a lot of case law. It's quite subtle, and it's very much context specific, so that whether or not in a particular case a decision should or shouldn't be justiciable is not something that's a sort of, at any rate in most cases, not something which is a very simple black and white issue. It's much more subtle than that. And we just didn't think that, I mean, there are certain categories, of course, which are not justiciable and never have been. Issues of foreign policy, issues concerning the way in which government deals with national security, things like this. And there's really no point in putting that into a statute because there's no issue, there's no problem there. The problem arises in the borderline cases, the difficult cases. And how on earth can you legislate for that? You can't, it's just not possible because it's all far too complicated, far too fact-specific, context-specific. I think it's a crazy idea. And we all, I mean, crazy is the word I use. We haven't said that in our response. But I just don't think it's a wise thing to do. And I fear this is a knee-jerk response by the government to their fury at losing the
prorogation case.
And as for all the other stuff, well, we have responded in detail to some of their proposals about standing and so on. We don't actually think there's any real need to make changes. We've suggested one or two possible changes of a technical nature because we didn't want to appear to be completely complacent with the status quo. And so far as tightening up yet further the procedural requirements for judicial review, I mean, the fact is that it's only a very few years ago that the government had a go at this. And I was MR at the time and therefore head of civil justice at the time. And I had discussions with Chris Grayling about this. And he was persuaded to modify some of the more extreme proposals that he put forward. But the fact is that some of the proposals that he put forward then and have been in place now for about 5 years have had a very significant effect in reducing the number of judicial review applications. And in the field, for example, of asylum and immigration, I think the number of cases received by the upper tribunal about 5 or 6 years ago was something like 15,000 a year. And now it's down to about 5,000 a year. So, I mean, I don't honestly think, unless you want to just put an end to the whole of this thing, which I'm sure the government would like to do, although they say, of course, they respect the importance of the rule of law. But in reality, they would love to see this all disappear in a puff of smoke. But if you're not going to do that, then I really don't think there is much scope for tightening up things further. And that's what we've said in our response.
Do you know, by the way, whether your response is available on the website of Justice? Has it been made public? Do you know?
I don't know, I'm afraid.
Yeah, well, we'll check, because I know that the Law Project has done a response which is available and which sets out, for example, the data you're talking about in terms of the numbers of judicial reviews brought over the last period of time, and shows exactly what you're saying, that there was a distinct, dramatic reduction following on, what are loosely called the Grayling reforms, and which you do talk about in the book. I want to get to some of the other questions because it's some interesting ones. So there was another question about noting that Lady Black has recently announced that she'll be stepping down from the Supreme Court, which will leave once again only one woman on the Supreme Court, and whether you think that the appointment procedure, which has been criticised, is not really good at kind of changing demographic patterns on the judiciary.
Yes, well, this is a subject which I feel very strongly about. I'm very sorry that Lady Black is retiring so early. I don't know why she is, but she is. When I was Master of the Rolls, the number of female Lady Justices increased from 4 to 9 during those 4 years. I was very proud of that. There are limits to what you can do because, of course, you've got to persuade women or the ethnic minority applicants, you've got to persuade them to apply. We can't do it in any other way. I did persuade some women to apply to the Court of Appeal, sometimes with difficulty, because I think that one's got to be so careful here about making generalizations, but I will make one nevertheless. I think that often women are less willing to push themselves forward than men. I know my wife found this when she was teaching, that it was the male students who tended to push themselves forward more than the females, and she had to shut them up to let the women have a say. So there is an element of that. But I think that one of the good things has been at the lower levels, the High Court, where now I think we have about 25% women, which is a distinct improvement. It's not good enough, but it's a big step in the right direction. And I think what's happened is that the more excellent women do apply and get appointed, the more other excellent women will be encouraged to follow suit. I think there is an element there of being encouraged by seeing your peers, or in this case, fellow women, doing it, to encourage you to do the same. I think that's a very potent factor. But so far as the Commission is concerned, I mean, they can only operate on the basis of people who apply. I think that more work needs to be done to persuade women to apply, and not necessarily only from the traditional pool of the bar. There are loads and loads of brilliant women, well, now brilliant women at the bar, but brilliant women also in the solicitor's profession and also in academia. I mean, there's no shortage of brilliant women who would be terrific at doing the job. It's a question of persuading them to apply. And I think more effort has got to be made in that direction.
Thank you. So our wonderful Yves Bonavero, who is in many ways the person who made the Bonavero Institute possible, is attending this afternoon, and he wanted to say how delighted he is and proud and grateful that you are a member of our advisory board, which I mentioned at the outset, and certainly it's wonderful for me and for the rest of the Bonavero team to have you there. But he also said that he very much enjoyed your compelling memoir, and he thought he likes the title, it's A Judge's Journey, but he wondered why one identifies oneself very much with one's profession, and that in fact, you know, you've been a human being for a long time and a judge for 23 years. And what is it about us as human beings that we identify ourselves by our profession? And is it something we should be a bit concerned about?
That's a very interesting question. So that's prompted presumably by the title and the use of the word judge.
Exactly. Yes.
I think I'd never thought of this before, but I think probably the reason for choosing judge in the title was in the hope that this might be more appealing and interesting to the readership. Because you've got to put something in there, and if you just put journey, I don't think it's any more significant than that. But I think he is right to ask the question whether it is the case that people like me do identify themselves very much with their career and their profession. And I think that's fair. It's a fair point. It is an all-consuming profession. I think you might well agree with that, Kate. It is an all-consuming profession. It's a brilliant profession. It's so fascinating. I have other interests in my life. I mean, I've been blessed with a wonderful family. And music is very, very important part of my life. I still play the piano. I
just interrupt you there because you do tell a story in the book about playing a piano accompaniment to a lecture delivered by one of our other advisory council members, who I think is also here this afternoon, Stephen Sedley. And I just thought that was wonderful. I couldn't quite imagine how it happened. So if I can just interrupt you and ask you to tell us a little bit about that.
Well, I think Stephen is probably better able to tell you about it than I am. I know that he was very keen. I haven't got the details of this in the forefront of my mind now, but he was very keen to do something slightly different, and so I think the song was based on My Way. That was the song, and he'd written some words. And it didn't go very well, as I remember it. But I think he berated me during our performance for not keeping up with him or something. But I think everybody enjoyed it. But I've never done anything like that before or since. But I still do play the piano quite seriously.
Yeah. And you do a lot of hiking. You do talk about that in the book, and your love for the Alps and for mountains comes through in the book very clearly.
Yes. So, but I have to admit that the law has dominated. It has.
Yeah. So then a couple of questions about the current measures taken by the government in response, in an attempt to curtail the spread of the COVID-19 virus, and whether you agree with Lord Sumption's concern that these have been adopted with a cavalier disregard for the limits of the government's legal powers, but also perhaps for, and I think Lord Sumption has said something of the sort, for human rights generally. I mean, what is your view on whether getting this balance right between, in attempting to curtail the spread of COVID-19 and at the same time acknowledge that, people's rights of freedom of movement and so on need to be protected?
Well, I don't have the confidence of Lord Sumption here. I think the government, the government have made mistakes, there's no doubt about that, and they've been all over the place. But they have been faced with an enormously difficult problem. And I don't think one should underestimate the difficulty. I would have hated to be in the Prime Minister's shoes in having to make these decisions, because the fear of the hospitals being overrun, overwhelmed, is a very real fear. And it's very easy to say, just rely on herd immunity or just let nature take its course because you can't interfere with people's freedoms. I think there are certain times when you have to interfere with people's freedoms, I'm afraid, and it's a question of balance. And I wouldn't presume to offer a different approach. I just don't think I'm not privy to all the information that the government has. This may seem like a rather feeble answer, but I think this idea, this libertarian idea of saying, well, let everybody take care of themselves, I think is a rather cruel philosophy. It's all very well if you're like someone like Lord Sumption who can take care of himself, I'm afraid to say, and I can take care of myself. And probably all the people listening in today can take care of themselves. But there are huge numbers of people in this country who can't, who are disadvantaged and who are not very clever and not very able to take care of themselves. And I do think that in a crisis such as we're currently facing, that the government does have a duty to, if you like, to protect people, to protect everyone, and trying to find the right balance. They're struggling hard to find the right balance. It's quite obvious. There's a real tussle going on there. And I would be slow to criticize them. They've made mistakes, of course, but I'm afraid I don't take this rather strong view that Lord Sumption takes.
Thank you. And there's a related question, which is, what do you think of the role of courts in times of emergency? And to some extent, I think your answer to the previous question, indicates something of an answer to that, which is whether judges feel some pressure. And the questioner says, in light of the atmosphere of criticism, to defer to claims of necessity and proportionality in times of crisis, or whether you actually think that judges will be able to make good calls on whether in fact a case has been made out for a limitation, or and a case of proportionality has been made out. And what is your sense about the role of courts in, I suppose, scrutiny of the work of the executive in times of emergencies?
Well, I think, as you say, I've effectively answered the question already, really. I think, I made a lot of decisions which were against the government, and I don't lie in bed at night thinking about decisions that I made several years ago. But I think one has got to adopt a sensible, fair approach to these things, and I do think a certain degree of deference is called for in a situation like this, where there are arguments on this way and that way, and it is extremely difficult. And I think I myself would only interfere with a decision of the executive in an area like this if it was clearly demonstrated that the government had got it wrong. I would want to be persuaded so that I was really convinced. And if there were doubt, then I would give the benefit of the doubt to the government in an area like this.
Yeah, thank you. So then there's another question, which is what advice you would give to prospective young judges, and particularly what they should do to avoid the pitfalls that they may otherwise fall into.
That's a difficult one, isn't it? One of the things that I think I think it's very important that judges should give their decisions quickly. I know one or two judges find that difficult, and it may be judges like that are not really temperamentally well suited to be judges. I think they need, before taking on an appointment, they need to ask themselves whether they suffer from writer's block, if you like. Whether I never suffered from that. Because I think it would have been an impossible job to do if you just allowed the judgments to build up. And I do remember there were one or two of my colleagues in the Court of Appeal particularly who had about 12 reserved judgments, and that was impossible. I mean, and I think one would get very stressed indeed. So I think that is, I don't know whether you would agree with that, Kate, but I think that is a very, very important point. Most of it is just common sense and fairness. I mean, you've got to have common sense and a sense of fairness. And if you don't have those qualities, I'm not sure you can teach them. If you don't have those qualities, I don't think you're really suited to be a judge. So, but there are lots of tips that one can give, which I did give particularly when I was Master of the Rolls and a new person came in. I gave all sorts of tips, which we don't really have time to go into, but there are tricks of the trade that one can learn. But the fundamentals, I don't really think can be taught.
Yeah, thank you. And then just one last question from one of my colleagues was to say whether you might say a little bit more about judicial training and how it's developed over the last 20 years in the UK, and particularly thinking about issues like training about judging in a diverse society, and whether you think that there's been good progress and whether there's more work to be done.
Well, I find it difficult to say whether there's more work to be done. I suspect there's always more work to be done. But training on diversity is something I was involved in quite early on, because I was asked to be, again, it was Lord Taylor asked me to be the chair of what was then called the Ethnic Minorities Advisory Committee, which then during my time became the Equal Treatment Advisory Committee. And we focused very much on judges being trained how to be sensitive to ethnic minorities and their particular perspectives and problems, if you like. And there was a lot of opposition to that in the early days by senior judges who were totally convinced that they didn't need any training in this area at all, because they were not, they didn't discriminate against anyone on the grounds of race or anything else. They were the ones, in my view, who were in most need of training. They were the ones who just didn't get it. And that the younger ones did understand it, did welcome the training. I would like to think that, but I can't prove, that today the judges are much more sensitive than they were in those days. I think some of the old style judges were frankly pretty appalling. I came in at the tail end of that. I encountered one or two of them early on, but I think there was a big change during my time. I'm not saying that all judges are perfect, of course they're not, but I think there has been a big improvement. As to training generally, yes, judicial training was something that was in its infancy when I started. We had the bench book that was given to judges conducting jury trials, and I found that immensely helpful in giving advice as to how to sum up to a jury on various aspects. That helped me enormously to avoid pitfalls, of which there were, no doubt still are, very many. As to the only thing I think I would mention is that writing judgments, that is something which I received no training on at all. I just did it my way based on what I thought was the right way to do it. But I do remember that the Judicial College once put on an event at which the great Lord Bingham spoke. And we all thought we were going to learn from him how to write a good judgment. But we were all, I think, greatly disappointed, because he said, basically, I can't tell you how to write a good judgment. You have to, we all do it in our own way. And he didn't really, he was very disappointing. I think I would have given a few tips, because I have given a few tips in my time, but he didn't really give us any tips. He just said, well, I wouldn't presume to tell you how to do it.
Yes, well, I mean, I suppose some people are good at doing it, and some people may be better at training people to do it. So everyone has strengths and weaknesses. Well, we've slightly overrun our time, but just want to say a very, very sincere thank you, Lord Dyson, for being so willing to talk about your career, to talk about the book, and again, just to commend the book. It's kind of openness and engagingness. I think people who've been listening this afternoon will be able to appreciate. It's a really an unusual and worthwhile account of a judicial career. So thank you very much for being here. Thank you for writing the book, and we look forward to seeing you again soon. And thank you to all of those of you who've been here through this conversation. It's been very nice to have you, and to just remind everybody that we have 2 more events in the coming week. So one is Joshua Rosenberg in conversation with Lord Thomas and Professor Paul Craig and Helen Mountfield about his book called Enemies of the People, How Judges Shape Society, which picks up many of the themes that we've been discussing this afternoon with Lord Dyson. And then next Tuesday, our new British Academy Global Professor, Martin Scheinen, will be talking about human rights compliance in relation to the COVID responses, something we've touched on as well today. And he will be responded to by Professor Jeff King from UCL. So please do register for those events if you'd like to continue some of the themes that we've picked up today. Thank you very much indeed, John, and hopefully we will see you again before too long.
Thank you very much. Thank you.
Bye now. Bye, everybody.